सब्सक्राइब कीजिए हमारे यूट्यूब चैनल शॉर्ट हैंड डिक्टेशन लीगल मैटर्स को और दबाइए इस बेल को ताकि आपको मिल सके हमारा वीडियो सबसे पहले और यह बिल्कुल फ्री है। रेडी स्टार्ट। In paragraph 102, the full bench has stated that there is no specific provision for affording opportunity before issuing notice under the provisions of 48 within bracket 2 of Municipalities Act. Thereafter, in paragraph 104, it has been held that even if the cessation of financial and administrative powers are a step in finalization of removal proceedings, it may still attract the principles of natural justice. In paragraph 108, it has been held that in the case where a head of a local body is deprived to exercise financial and administrative power and ultimately the proceeding for removal are dropped, then in such an event his loss can never be compensated. A post-decisional hearing cannot cure the harm oblique damage done to him. The full bench has held that for lawful cessation of administrative and financial powers, it is necessary that the explanation or the point of view or the version on the facts of precedent should be obtained on the recorded charges and should be considered before recording satisfaction in issuing notice oblique order under the proviso to section 48 within bracket 2 of the Municipalities Act 1916. We may reproduce the relevant part of the conclusion as per paragraph 133 of the full bench judgment, which reads: our conclusions are that there can be proceeding for removal of president under section 48 within bracket 2 of the Municipalities Act without seizing his financial and administrative power under its proviso. The following conditions must be satisfied before cessation of financial and administrative powers of a president of a municipality can take place. The explanation or point of view or the version of the affected president should be obtained regarding charges and should be considered before recording satisfaction and issuing notice oblique order under proviso to section 48 within bracket 2 of the Municipalities Act. The state government should be objectively satisfied on the basis of relevant material that section 48 within bracket 2 of Madhya Pradesh Municipalities Act 1916. The full bench of this court has not examined the aforesaid aspect of the matter while coming to a conclusion that opportunity of hearing has to be afforded to the president before seizing the financial and administrative powers after a notice under section 48 within bracket 2 has been issued. We therefore find ourselves unable to accept the law as laid down by full bench in the case of Hafiz Ataullah Ansari versus State of UP Supra. It is settled law that if the words of statute are simple and admit of only one meaning, then no rule of interpretation is required to be invoked by court of law. The simple meaning has to be given effect to irrespective of the hardship it may cause. It is by operation of law that the financial and administrative powers stands seized automatically oblique invariably once a notice under section 48 within bracket 2 of MP Municipalities Act 1916 is issued and no separate orders are contemplated under the provision of the Act. Since the rights of petitioner have been put in jeopardy and he has a limited term, we request the Honorable the Chief Justice to constitute a larger bench for deciding the aforesaid issue if possible in next 2 weeks. So far as the impleadment application is concerned, petitioner is at liberty to file objections. Stop.